And thank you to those who are joining. We will begin in just a few seconds. Good evening, and thank you all for joining us. We will be providing updates this evening on the federal KCPA, Georgia, Maryland, and California, just to name a few. The Q&A is open, and I will now turn it over to Mac Haddo, Senior Fellow on Public Policy for the AKA.
Thank you, Ryan, and welcome to all of you who are joining this evening. Thank you for your time. These are really important meetings because it allows us to share some information, and there's a lot of information that's really breaking even as we speak here that really is important for everyone to know in order to keep context in the argument that we're making that we really need to protect consumer access to safe, properly regulated and properly manufactured Kratom products. And I was on an interview with a reporter from Florida this afternoon, and she asked me why it is that we feel comfortable in challenging the U.S. Food and Drug Administration on a decision that they had made, because obviously they are the premier health protectors in the United States. I would like to believe that. I know that many of the employees at the FDA, the thousands of them, that most of them are really dedicated to do the job that they're tasked by the US Congress through statutory authorities to do. They want to protect the American public. But that's not true for that group of people at the FDA who have leadership positions that are exercising what I think by any standard arguably is an overregulation of the marketplace in order to prosecute their own bias. And we've talked about this many times before, that the FDA does have a bias against botanical and dietary supplements, and they regularly try to interfere with the ability of consumers to have access to those products. But I thought the great example, and it's really being highlighted today as the details of the settlement that the FDA was forced by the courts, compelled actually, in order to reach with a couple of doctors in Texas who fought back. And that was over ivermectin. Now, it really doesn't matter where you stand on the issue of ivermectin in relationship to COVID and the potential therapeutic value that that particular therapy has. That wasn't the issue. The issue was that these doctors felt that the pronouncements by the Food and Drug Administration, which were not based on science, but rather on the bias and the actual opinions rather than well-documented evidence and data. And the FDA made several statements about how ivermectin was dangerous, how ivermectin shouldn't be prescribed, and they went overboard. They went too far and certainly well beyond their statutory authority. So a couple of courageous doctors sued the FDA. And the Fifth Circuit Court came down hard on the FDA because of the disinformation / misinformation that they were circulating about ivermectin, and most particularly about the doctors that were prescribing it. And the courts were obviously headed in the direction of finding not only for those doctors, but also to award them damages for what they had experienced at the hands of an FDA that had simply gone too far. That settlement now, and the details were just being circulated today, includes a withdrawal by the FDA of statements that exist on their website now have to be taken down. I look forward to the day when the FDA, and perhaps not because they're compelled in the court action, but rather listening to the evidence and data of good science about Kratom, that they will do the same thing, that they'll remove the disinformation. In the next couple of days, you're going to have the opportunity to do something that's unique in our society in terms of speaking out, much like these doctors did in challenging the FDA. We're putting up a website that's FDA Truth website that will allow you as an individual consumer to file a complaint against the FDA under what's called the Information Quality Act. That will allow you to specifically identify the disinformation or the inaccurate information that the FDA is circulating about Kratom or about other dietary supplements and botanical supplements in which you may have an interest. This will go widely to all interested consumers who believe that the FDA is engaged in this campaign of disinformation against these kinds of products simply because they're not new drug applications, simply because they are not the kind of applications for approval that will generate significant revenues to the FDA. There is no Prescription Drug User Fee Act that applies to dietary supplements or to botanical supplements. And that's sort of the heart of the issue when it comes to trying to understand what the bias that the FDA policy people have against these kinds of products. I think that the tables might be turned a little if, in fact, they saw a revenue stream, as they do with new drug applications, that sustain a significant portion of the agency's budget today. But that's inconsistent. To do that would be inconsistent with the mandate that the Congress has given to the FDA not to treat these products like they are prescription drug products, but rather to be, as Commissioner Califf last week in a hearing before the House Oversight Committee, when Commissioner Califf was trying to defend the inaction by his agency and the poor enforcement mechanisms by his agency, he tried to explain to the Congress that in his view, he needed more statutory authorities, and because the FDA only serves as the referee. That's what he claimed. Now, that's a proper role for the FDA in the area of dietary supplements and botanical supplements, to be that referee when, in fact, there is a dispute that arises or an alleged claim against a product that needs to be investigated. But you can't be both things. You can't be that heavy-handed bureaucracy that demonizes and says, like they did with ivermectin, without good science and data, that this is a bad product, no one should be using it, and the people that are prescribing it or selling it to you are somehow doing that illegally. That's where the FDA is today when it comes to Kratom, and we hope that we are going to get them in a position shortly that they will have to correct that misinformation. So take advantage of the FDA Truth website when you have a chance to visit it, and you'll be able to file your own individual complaint that we will submit both to the FDA and to the United States Congress to illustrate how the FDA is wrong about the way that they are regulating or failing to regulate botanical supplements like Kratom and other supplements in this space that the FDA has a clear and unmistakable bias against. Take advantage of that opportunity. Another thing that I was asked about by this reporter, which I think is timely, is what the true impact of the FDA's dose finding study on Kratom is. It is important not to overstate what it is, but it's also equally important not to understate it, and that's what our critics are trying to do. You will hear them say, oh, well, that study has limitations. It is critically important to understand what the purpose of that study was. And remember, the FDA's view was that Kratom was not tolerated at any dose level and was unsafe at any dose level for a human to consume. But in order to do the study that they really want to get to, which is a human abuse liability study, they had to do a dose finding study. And in order to construct a dose finding study, they have to let humans, in this case, there were 40 subjects that were part of the dose finding study. They started out at a very low dose. They called it a single ascending dose study. They started with 1 gram, they kept escalating, and the idea was to get to a level at which there would be an adverse event. Didn't have to be a serious adverse event. It didn't have to be an adverse event that would disqualify someone from the study from continuing to participate, because those things happen in dose finding studies. In this case, they only wanted to show whether Kratom was safe so that they could ethically then administer Kratom products under a human abuse potential study that they plan to conduct next. They can only do that if they can demonstrate the safety profile of Kratom. That was the purpose of the dose finding study, and the results astounded the FDA. One of the researchers that was directly involved in the evaluation of the dose finding study, I think, said it right. He told me, he said, the FDA policymakers were profoundly disappointed in the result. I imagine they were, because if you believe the statements that were made by the FDA in their prior submissions and recommendations under the Controlled Substances Act, which requires them to identify what the threat of safety is to the American people under Factor 6 of the 8 factors that are considered in a scheduling recommendation, the FDA twice said that Kratom posed a significant risk to the safety of the American people. And yet today, they will acknowledge, not on their website yet, but through presentations made by FDA scientists, that in fact they got to 12 grams in a 5-minute period. So I told this to one legislator in Maryland who said, I would get sick at anything if I had to consume 12 grams of some substance in a 5-minute period. 2 of the participants experienced nausea. That is not a disqualifying event. That is not an endpoint because there was no significant adverse event. There was nausea among 2 of 40 people, which confirmed to the FDA that they could ethically proceed with doing the human abuse potential study because by the FDA's own conclusion, Kratom appears to be well tolerated at all dose levels. Now, that's a dramatic shift. It is in the FDA's position because for the last decade, they've been saying Kratom's deadly, that it's dangerously addictive, that this is a substance that if it's taken, people will be suffering from all sorts of organ failures. They'll be writhing with seizures on the floor at small doses. And they got to a huge dose of 12 grams, and they had no such events take place. So now it's cleared the way. So in its proper context, that is what the FDA now has demonstrated on the record with a human study for safety that they can proceed with this. And more importantly, it is the start of what I think will be a seismic change in the FDA's position about the safety profile of Kratom. It has to move because they cannot expose themselves to the continued risk of being outside of the mainstream of science where they are right now. And so this was a great event for the Kratom consumers because it will compel the FDA to change its position. I think you're eventually going to see a change in the FDA Kratom website that the FDA has right now, which continues to make the argument that Kratom, that despite the fact they've morphed the language a little, that Kratom represents a threat to the American people because it is, quote, adulterated. In order for the FDA to make that pronouncement and to use it as a policy position, they are legally required to conduct rulemaking, which is a very lengthy process, which allows for stakeholders, you and I, and scientists to weigh in. That never happened. The FDA didn't bother to go through the procedures that they're required to do if they want to make that kind of definitive statement about any substance, and in this case, Kratom. So the FDA is currently outside of the statute, and we think they're going to be held to account for that. I believe that Commissioner Califf will see the light on this and start to move his agency into a more moderate position. We have already seen that in a discussion that the deputy commissioner of the FDA had in the webinar that was held by a pro-FDA group called the Alliance for a Stronger FDA. That's a group that annually argues for increased funding for the FDA in order to allow it to do its job properly. And in that presentation, the deputy commissioner of the FDA was asked, what is the position today of the FDA on CBD and Kratom? And her answer illustrated exactly the shift that's starting at the FDA when she responded to that question and said, well, we're going to work with Congress in order to get new statutory authorities because we want to make sure that CBD and Kratom are manufactured correctly. We want to make sure that when it's marketed, that it's labeled properly so that warnings are available to consumers about the potential risks of using Kratom. And we want to make sure that it's not available to kids. That's the Kratom Consumer Protection Act. And you can see they're starting to move away from their prior position, which says it's dangerous and deadly and you should schedule it. Now they're talking about regulating it. And of course, that's where we want to be when it comes right down to it, because ultimately, Kratom needs to be regulated so that there are responsible processors, manufacturers that are using the correct GMP, good manufacturing practices, and labeling their product, and of course, specifying what the serving sizes are and what the number of servings you should have in a day. That's the sweet spot for this, and that's where we're going to find, I think, the FDA in the next couple of years evolving to that position. But ultimately, the Congress is going to do what they did in 1994 under the Dietary Supplement Health and Education Act, when the FDA, for years prior to the enactment of that law, had been telling everybody who would listen that dietary supplements were poorly formulated, they were adulterated, that they were killing people, they were causing significant adverse events, and there were multiple reports to the poison control centers. That's the same playbook that they used against Kratom, that they continue to use against Kratom, and that we're going to now change that narrative and compel them to do so. So I think that in its context, the dose finding study needs to be viewed for exactly what it is. You will hear the trial lawyers just barking into the wind, saying, oh, it's a limited study. It doesn't mean anything. It means a lot, because it means so much that the FDA is now authorized to proceed with this human abuse potential study that cost millions of dollars, and they will have to be held accountable for how that study is conducted as they go forward. I know some people believe that the FDA will try to put their finger on the scale, and I think that's probably true. But we can hold them accountable as we review the protocol that they use, and there are plenty of scientists who work in this field who understand it. And I can tell you that in the scientific group at the FDA, it is not the same position that's held by the policy people at the FDA. And these scientists value their integrity. And I think as we see this issue evolve and as these studies proceed, that there will be a self-regulating factor at the FDA, because I think these scientists want to get it right. Now, unfortunately, it's a long process, because even to do the dose finding study, which was done on pure leaf product, and we're going to talk about extracts a little later in this webinar, all they did was test for that. They didn't look at extracts, and so their human abuse potential study cannot include extracts, which we hope to get to a study on those, and we should, and that ultimately will take another dose finding study of those kinds of products and then go forward with its own human abuse potential study. We're looking at 3 to 6 years before that data will come. Commissioner Califf doesn't want to take any step on Kratom until this data and evidence is available. That's too long to wait. The commissioner respectfully is wrong, because you can't demonize, ban, and try to take a product off the market because of what your opinion is. It's got to be based on science. And if anything, the science should tilt back to consumer access of Kratom, not to ban it until he figures out what is inevitably going to be the result, that Kratom is, oh, I don't know, the FDA said it, well tolerated at all dose levels. So I think it's great news for us. We'll continue to carefully monitor as we go forward. Don't listen to the chatter of the trial attorneys, because they will try to put a good face on any bad news that they got. And this was bad news. And they know it, and they in their heart, they understand it. They would just like to mischaracterize it, because their audience is not us. Their audience is the anti-Kratom crowd and their clients, who have a financial interest in making sure that the FDA is right. And so they'll try to spin it. They'll try to recharacterize whatever's done in order to promote their financial interest in doing so. I believe, and I think it's something that most of us share, that those families should have the answer, and the answer should be the truth. We know, and I hope all of you understand, that we fought in every way that we can in order to get good information and have it evaluated by independent experts when it comes to alleged Kratom deaths. Every autopsy we've gotten, we've submitted to a forensic toxicologist for review. There hasn't been a single death that can be attributed to Kratom alone. It's always polydrug use or underlying health conditions or other novel substances that the individual was exposed to that on the original cut of the testing wasn't identified. In Ohio, and I hope all of you know this case, a distraught mother called me because the medical examiner, the coroner in that particular county in which the death occurred, characterized the death of her son as a metrogenine intoxication death. She objected strongly because by her description, her son was saved by Kratom, that he had been an addict to some of the substances that were ruining his life. And she believed that he was going to die because of it, but he found Kratom and Kratom saved him. And the only evidence that was available to the coroner's investigator at the time of the death was a bag of Kratom product on the nightstand of this individual. And right there, at that instant, the investigator said to the mother, "We're going to call this a Kratom death." And she objected strongly enough that the investigator said, "Okay, we'll wait the 8 to 10 weeks until we get the tox screen back." The next day, early in the morning, the coroner himself called this mother and said, "I have sufficient information to determine that this is a Kratom-caused death." He was wrong, but that's what he said. He didn't wait for the tox screen, but more importantly, he did not have any evidence that was available to him for which that conclusion could have been drawn in order for him to make that determination, and yet it's on the record books. That's what it was. And so we helped this mother sue this coroner. And just 2 weeks ago, 2.5 weeks ago, this coroner acknowledged, based on, as by his description, based on a review of new literature, the conclusion this was a kratom death was not supported by the science. And he changed it to a cause of death is undetermined because there wasn't blood drawn that would identify other toxic substances that might have been in the individual's bloodstream or other health conditions because of one reason. They targeted kratom. When the request was made of the NMS Labs, which is the leading forensics toxicologist firm in the country, used by this coroner to identify what drugs were in this individual's system, when we subpoenaed that record, NMS Labs said we weren't asked to test for anything but metrogeny. Now look at all of these deaths that keep getting reported by trial attorneys and by medical examiners and coroners that say these are kratom-caused deaths, and now the house of cards starts to fall because there simply isn't good evidence. They've all been on this gravy train that the FDA set in front of them that they could just slop into and say, oh, this is the easy conclusion. If you see kratom is involved in your investigation in any way, then you can call this a kratom death. And we know that that's simply not true. And now the evidence is now going against them. Everyone should know that even in that hit piece that was run by the Tampa Bay Times with the headline "Deadly Dose," even those reporters admitted on an interview that I was on with them that there is no known toxic dose that any scientist has identified that would be the cause of death for a so-called kratom intoxication. There is no death level or toxic level where that kind of conclusion could be drawn. But they identified 46 deaths, maybe it was 48, whatever that number was, deaths in Florida based on their review of autopsies that were given to them, the conclusion of which were drawn by medical examiners and coroners in the state of Florida. I said to them, you can pick the lab and we will pay for every one of those blood samples to be tested, and we'll live with the result. But let's find out what the truth is. Don't rely upon information that was drawn from the same way that the Ohio case was done on incorrect or inadequate information. And do you know what the Tampa Bay Times reporters said? The people that were involved in trying to find the truth, they said, no thanks. They weren't interested in finding the truth. We were willing to pay for it, and they weren't willing to try because it didn't fit their narrative. It was a biased hit piece. It is a shame that a newspaper that depends upon its credibility would throw it away so easily. But understand that they had invested 6 months of time, $400,000, and that's suspect as to where that money came from. And they said that they had put 4 reporters on full time. And they didn't want their narrative, that deadly dose narrative, to be upset by the facts or the truth. And that's where we find ourselves today in an environment where there's a lot of disinformation. There's a lot of people who believe sincerely that kratom was the cause of their death because it's convenient to do that. It's just one of those situations that we all confront, but it's unraveling. And we're going to do it one death at a time as we need to in order to proceed. So I think this is an important moment for the kratom community to understand that we're right at the point where the shift is occurring because the truth is starting to emerge. And I know since 2016, we have stood shoulder to shoulder fighting this battle. And it's great to see now that things are starting to come into much clearer perspective by public policy officials. And that's why we're being so successful with the state KCPAs. We're working at the federal level, and I'm convinced that over the next 2 years, we're going to get a Kratom Consumer Protection Act at the federal level, which will finally resolve the FDA's antagonism and force them to do the right thing. But we have some bills that are hot on the presses right now that we're working on. Let me first talk about Georgia. The Georgia HB 181 was a terrible bill. When it first started, it was a ban bill by Representative Townsend. Representative Townsend clearly saw that the headwinds were against him, and so he shifted fairly quickly to the Kratom Consumer Protection Act. And we had some very good conversations with him, but he was, make no mistake, he was captured by the trial attorneys. They were feeding him the information. They were giving him their case logs saying, here's people that have been in their view, have been killed by Kratom, and he bought it. He bought every bit of it, hook, line, and sinker. You can watch the hearings from over a year ago in the House committee hearings, and you can see how he was talking out of both sides of his mouth. He couldn't answer basic questions. He tried to blame other states for not doing it right. And what he said was the 2019 law that was passed in the state of Georgia was inadequate. Remember, he wanted to ban it, and then he was going to shift to regulation. And the basis for his claim that it was inadequate was there was no state agency that had been delegated by the statute that would enforce it. And so his claim was that there was rampant violations of the standards that were set in the 2019 law. He has to live with that because that's what he said. And after the passage out of the House and the subsequent debate and negotiations, all of which came under the control of the trial attorneys and their allies in the Georgia legislature, the bill that came out has one huge glaring defect. It has no state agency which is identified in order to enforce the provisions of HB 181. It does not. Now, how can Representative Townsend, with a clear conscience, with any credibility, stand up and say this is a good bill? It does one thing, and that is it allows for an expansion of the number of retailers and processors that can be sued by the trial attorneys to add to their list of defendants. It will create havoc and chaos in the retail community because these retailers are going to be brought into these lawsuits and they'll have to defend against them. Even though they're not legitimate, they will still have to pay for attorneys. And all this is the Trojan horse. And that's all this bill is the Trojan horse for trial attorneys. We're hopeful that the governor of Georgia will veto this bill because it deserves it. We want to come back and work on a real Kratom Consumer Protection Act that has enforcement teeth. When asked by the Senate Health Committee members, what is the enforcement mechanism of this bill? And Representative Townsend said, oh, it's local law enforcement, sheriffs. Now tell me what sheriff, number one, even knows what Kratom is. There are very few that do. Tell me what sheriff would be able to actually look at and identify whether the product is mislabeled, whether the standards of the product being met in terms of serving sizes, whether the content of the product with metrogeny, 7-hydroxymetrogeny, and other alkaloids are properly identified. How in the world could they do that? They can't. The charade that Representative Townsend, the shameful charade that he allowed to be done in his name by the trial attorneys, has now left him holding the bag, and he deserves it because he should have done better by the people of Georgia. And whether we get the veto or not, we're going to be back next year, and we're going to be amending whatever law may get enacted if it doesn't contain those basic protections for consumers as we go forward. It's easy in this environment for a freshman legislator like Representative Townsend to be misled. But when the opportunity was available for him to have a discussion with Kratom consumers, with the American Kratom Association, he went and hid behind closed doors in a negotiation with the trial attorneys and with the leaders in the Senate, telling them that the AKA supported what he was doing. That was a lie. He knows it's a lie. And when I confronted him with it, he said, oh, well, I just thought you guys would support this. And I had told him repeatedly that we did not. And worse, you all saw the picture when he was confronted with the question in the Senate Health Committee about what the enforcement mechanism was. He could not answer it. He couldn't even spew out the answer. It's local law enforcement. He had to rely upon whom? Matt Wetherington, the lead trial attorney in these anti-Kratom cases, had to go up to the podium, cover the mic with one hand, put his hand over his mouth and whisper to Representative Townsend the answer to the question that the sponsor of this bill, who railed against the existing legislation by saying it didn't have a proper enforcement mechanism, he had to have a trial attorney tell him what that enforcement mechanism was because he didn't know. That's legislative malpractice and a shameful thing that happened there. We hope that he learns from it, learns from the experience, but we're going to be back and we're going to be fighting for the people of Georgia, for the consumers there to have access to responsibly regulated Kratom products and not make it into the Trojan horse for these trial attorneys. So that's Georgia. I'll be down meeting with the governor's staff here in the next couple of days and having these discussions and hopefully convince the governor that this is not a piece of legislation that needs to be enacted. It needs to go back to the drawing boards, and we'll be willing partners in that effort in the January 2025 legislative session in Georgia. Some great news, on the other hand, is the state of Kentucky became the 12th state to pass the Kratom Consumer Protection Act with overwhelming numbers. It was a great victory for the Kratom community. We're glad that we've gotten that state under our belts now and continuing to work with other states, because as each one is added to the Kratom Consumer Protection Act, group of states who have passed that legislation, it creates an incentive for other states, particularly surrounding states, to actually join in. Pennsylvania and Ohio, as an example, and hopefully next year Tennessee are going to follow suit because Kentucky led the way. In Maryland, the Kratom Consumer Protection Act is not yet signed. The governor is expected to sign it. I'm fairly confident he will, because this bill passed 137-0 in the Maryland House of Representatives, and it passed 47-0 in the Maryland Senate. That is overwhelming numbers for a bill that will bring needed regulation to the Kratom marketplace in the state of Maryland. We're still working in this legislative session in Ohio, in Louisiana, in North Carolina, Pennsylvania, New Jersey, New York, Massachusetts, Rhode Island, a banned state, where we're hoping to get the Kratom Consumer Protection Act passed before the end of their session, and in Illinois. There's also a bill in California. Let me take you a moment to talk about California. The American Kratom Association has looked at California for a number of years. We elected because of the resources that were needed in order to pass a bill in the state of California. It usually is a 2-year or longer process. The cost of lobbyists in the state of California, because of the hugeness of the state, are very expensive. And we made the calculation that we could better utilize our resources by going to other states and pass the bill there, and eventually California would fall into line. There is a group, a competing group in some senses. We align on certainly the principles about protecting the Kratom marketplace, good manufacturing practices, but we don't agree with the regulatory approach that is currently embedded in the current version of the bill. So we're working with the Global Kratom Coalition to try to modify some of those provisions in order to make this a more acceptable piece of legislation, to make sure that California doesn't come out with something that would stop progress in other states, because people would point to it and say, well, why are they doing it that way? And why are we doing this with the less regulatory scheme? I think that I would encourage everyone to take a look at the two versions of the bills that are out there. We're working hard to protect the consumer, but not to limit the marketplace, nor do we want to see the state of California, which has a propensity to do it, become this super regulatory state agency that would simply create havoc and block products from getting into the marketplace. We think that if a product is properly manufactured, that if it's labeled properly, and there's an age restriction, that should be the sufficient regulatory framework that Commissioner Califf himself said is what the FDA does at the national level, where the state agency would be the referee, not being the judge and the jury. And I think that's an important distinction as we look at this bill. But we hope that we're going to be able to work out a compromise where we can get to a level of regulation that's acceptable, that won't interfere with our actions in other states. But just know for the moment, right now, we're not at a place of agreement with respect to California. We hope that California will pass a Kratom Consumer Protection Act that's reasonably framed. We will oppose it if it goes too far. And that's what we're hoping to work out with the Global Kratom Coalition. They're good people. They're an industry-based group that's working hard. But we want to make sure that we hit that sweet spot in the middle that protects consumers and doesn't protect Kratom vendors. And we think that's an important distinction that needs to be done. Some of the other great news in the current marketplace that we're in are the bans that are dead now. Nebraska, Senator Lippincott made an effort to try to ban Kratom. That is done. There's no chance for it. And we're hoping that others who were co-sponsors of his bill in the next legislative session in Nebraska will have a more reasonable approach to this, and we can have a Kratom Consumer Protection Act. The same is true in Mississippi. Mississippi is a constant problem for us every year, and there's always the competition between a ban bill and the KCPA. And unfortunately, we get into a situation where we compromise, and the compromise is always, we're not going to pass anything. And that, of course, doesn't serve consumers very well, because we know there needs to be good regulatory support in these states in order to allow for Kratom consumers to be protected. So we're going to continue work there. The ban bill in South Carolina is also dead. and we're grateful for that. And next year, we're looking forward to coming back with the KCPA in the state of South Carolina. The last thing I wanted to address that's timely, and then we can move maybe to some of the questions and answers if there are any that have it. And that is that the issue about 7-hydroxymetrogenine products. This is a very difficult issue because all of us understand that 7-hydroxymetrogenine occurs as a metabolite naturally in the plant material as after it's harvested and as it goes through the drying and maturing process and prior to it being actually manufactured into a product. But we know that there's in all the commercial products that are available in the United States prior to the introduction of 7-OH enhanced products, that the levels of 7-hydroxymetrogenine were not even detectable. And so our bills have always said that if a commercially available product in any state for which the KCPA is passed has a level of 7-hydroxymetrogenine that is greater than 2% of the overall alkaloid fraction of the plant, that is clear and unmistakable evidence that 7-OH has been manipulated and artificially synthesized in order to enhance its effect. Scientists are unanimous in their their consensus about this. The reputable scientists that have actually done research into it, there's still unknowns out there. There's still some science that may get started here that will give us better information, and we welcome that to the extent that it's available. But right now, the consensus of the leading scientists in the kratom field is that 7-hydroxymetrogenine, 7-OH, in its purified and synthesized form, represents a potential danger because of its greater affinity for binding to the mu-opioid receptors in the brain and the effects from that, and the fact that they are far more addictive than kratom would ever be in its natural form. Now, 7-hydroxymetrogenine as a metabolite also occurs in that process once the kratom product is ingested. That's why the lowest level possible that's evidenced in the natural progression of the plant as it gets to a finished product needs to be very low, because there is that naturally occurring metabolism. When you get a super enhanced, synthesized 7-OH product, it represents a potential threat to people. We don't have the science yet to understand what its true effects are. We have enough flares that have been sent up and warning signs based on the studies that have been done so far with respect to 7-OH. So we're hopeful that these products will be withdrawn from the marketplace, because they should be. And until the science is available that allows for them to be properly regulated, then I think they should wait for that event to come forward, because I think that's a synthesized product is not kratom. It is not the natural plant. And even though it has the attribute of being a part of the metrogenine metabolite in kratom plant, a synthesized artificial component of that does not make it kratom. And we're hopeful that we can, as I say, just kind of obliterate that problem as we go forward. I know that this also creates another problem. And that problem is that there's this controversy about whether pure plant material should be the only way that we present kratom products, or can we use extracts? To me, this is an important question. I think that both products that are derived from the natural kratom plant material and an extract material, if it's properly extracted using FDA-approved food solvents in order to extract the material, produces a safe product. And that's why we have to be very careful in limiting that extraction process. It's much like, and it's analogous to a latte at Starbucks. That is an caffeine product. If caffeine is synthesized or highly concentrated, it is a dangerous product. But Starbucks sells it in an extracted method because it's controlled in the way that the extraction method is employed to pull out that caffeine into that product. It has a different effect than the natural, obviously coffee product. And that's expected because it is in fact extracted into a more concentrated form. There need to be limits on that. And that's why we support very strict limits about what the extraction methodologies are in our KCPAs. And the truth is that when you extract a product using those methodologies that are appropriate and FDA approved, you get an important distinction between the raw leaf plant and the extract product. And that is that you've removed a lot of the microbial load that is present in these plant materials that could include things that are E. coli, salmonella, heavy metals, and that kind of thing. And you get a standardized dose. And for some people, that is very important, particularly if you're dealing with some of the acute and chronic pain issues that require you to have an extract product that may be more effective for you. You need to have that standardized dose. So I know that there is in our community a disagreement. There are the people that are the orthodox people that say we should only use the natural kratom leaf plant. But I can tell you that depending on the plant material that's acquired, you can have a wide range of what the metrogeny content of that plant material is based on when it was picked and how it was handled after it was picked and harvested. So this isn't a linear thing where you can just say, hey, this is a choice that I can make. Consumers can speak in the marketplace for what products they prefer, as long as that product meets the standards for safety that are ultimately required under the KCPA. So I think that that at this point, we are at a crossroads in deciding where we want to fall on this. And if we want to fight each other and say, oh, well, the 7-OH product is just like extracts, they are not. They are not chemically. They are not from the plant material. They are vastly different. And a synthesized 7-OH highly concentrated product is not the same as kratom. It shouldn't be called kratom. It has a component of metrogenine, which gives it that association, which I think is unfortunate and why we want to stay away from 7-OH products as best we can. We are simply going to have to keep this fight going, but internally we shouldn't be fighting among ourselves. Recognize the right of consumers to speak in the marketplace with their purchases, as long as they are safely formulated products, properly labeled, and of course restricted to minors. So I think that's as we go forward. With all of the discussion we've had thus far that I've described to you, there is another part of the fight that we're in that is discouraging, and that is the expansion of the number of local bans. These are very difficult to track. They're usually cooked by the staff prior to their even being announced on agendas, and so we have an uphill climb. One of the greatest disappointments I had was when we went to the Newport Beach, California City Council meeting, and we had what I thought were excellent presentations made by some of the leading scientists and policymakers in this country on kratom, and it was met with a wall of silence. Not a single comment and not a single question was asked. This was baked in, and the councilwoman who was responsible for that was acting on direction and misinformation, as we understand it, from a large addiction recovery center that had a financial interest in getting kratom removed from the marketplace. Not a very effective way of doing it, by the way, because all that happened there was that the city of Newport Beach lost the tax revenue that comes from selling kratom. They deprived consumers of easy access to it, and that's unfortunate. And I don't think public policy should be dictated because someone waves some money at you and says, hey, this is the policy you should adopt. Now, that's unfortunately part of politics in our society, but I don't think that should be the baseline. You can certainly accept their money and listen to their arguments, but the truth ought to prevail. And so we're seeing that in a lot of these local jurisdictions, there are people being misled by the FDA's position. I listen to people in those local jurisdictions that have zero context, and they will say, it's not just the FDA, it's the Mayo Clinic. Look at what the Mayo Clinic says. What they don't know is the Mayo Clinic has never spent one penny, not one single penny, on kratom research. They repeat what the FDA says. They repeat the disinformation. They repeat the misinformation. And so that's why our FDA Truth website is going to be very important for us to file our complaints and maybe get the attention of this ecosystem of circulating bad information. This is not the third grade rumor mill, but that's the way the Mayo Clinic is treating it, because they don't do any independent evaluation. They only listen to the FDA. We obviously want to be in a position to let the truth prevail based on good evidence, good data, to do what Dr. Brett Giroir did when he evaluated the FDA's case for recommending a scheduling as a Schedule I substance. And after a thorough, complete, and exhaustive evaluation, he called the FDA's evidence and data embarrassingly poor, and nothing has improved since August the 16th of 2018. In fact, it's gotten worse for the FDA's narrative. And yet you have these local jurisdictions that follow along like sheep on some of this stuff. We're going to continue to fight. We thank those that are diligently watching, helping us identify where these occur. We immediately send the information. But as I say, sometimes by the time it gets to that point in the process in local government, the staff has already greased the skids and we don't have a lot of success. Sometimes we do, but not a lot of success. But we're going to continue to fight, and we appreciate all of the efforts that you've had. So with that, I'm going to turn it back to Ryan, and we can field whatever questions anyone might have.
That's great. Thank you, Mac. First up, thank you, Mac, for your presentation in Richmond last Thursday night. I believe your message was received by some church and recovery leaders. Not sure if you want to make any comments about that meeting.
Well, let me just say that John Schinzelzer, who is a leading addiction recovery leader nationally and in Virginia, convened this meeting. And it was a little bit like going into the lion's den, because many of the audience members were in fact from the Addiction Recovery Center. The good news is that John Schinzelzer's message as a leader in that community opened the door for a discussion. Aaron Berthoud, who is a respected scientist in the Kratom field, was able to explain some of the critically important scientific evidence that impacts both the safety profile and the addiction profile of Kratom. And I think that was generally well received. I had the opportunity to talk about the policy to describe exactly the Kratom community, Kratom consumers, and their reliance upon safely formulated, properly regulated products. And I think that was accepted. There were some that weren't happy. I had a very robust discussion after the meeting with one of those very unhappy people. But the unhappiness was really a frustration at information that they thought they knew before the meeting started. So I think the educational effort was great. And I'm grateful to John Schinzelzer for having organized that event. And I think it's the start of a very healthy and important discussion in that community to bring them into the reality of what the evidence and data says about Kratom. None of them were aware of these recent developments with the FDA, with the dose finding study, with their refusal to go and testify at a federal court hearing in a courtroom under oath where they had to actually tell the truth. And the FDA declined to do so because they, according to them, on the court record, had not yet come to the determination whether Kratom was dangerous. That's a surprise. If you look at their website, they don't say that. And if you look at their history in the last 10 years of multiple pronouncements, that's not their position. But when they have to do it under oath, then they tell the truth or refuse to come and tell the truth.
That's great. My town of Orland Park banned local sales yesterday. Should I worry about that escalating to another ordinance for a possession ban? And what can I do? Also, how far along is the Illinois KCPA?
So yes, we're all worried about this, and there always is the opportunity to escalate. In my experience, once a local jurisdiction arrives at that decision, it's easier to keep them from expanding it into a more onerous policy. We're going to be diligent. Keep us posted if you hear anything different, but we're going to watch that closely. The Illinois KCPA has to be passed out of the House. There's some exceptions to this process, but we expect by the end of this week. And we think that's a great event, and I think that it will then move it to the Senate. We're in very robust negotiations with the Department of Health in Illinois. I think we're making great progress there in explaining to them how Kratom should be properly regulated. A little bit of an uphill climb for us to explain to them why the FDA is wrong, because they have an institutional bias to thinking the FDA is right about everything. But I think we're making progress there, and I'm optimistic that we're going to get the bill out of the House into the Senate where we can further those discussions with the Department of Health.
Great. And if the bill in Georgia is signed, what does that mean for out-of-state purchases? Meaning, can a consumer still purchase products from out-of-state vendors and have them mailed to your address in Georgia? Will out-of-state vendors stop selling to consumers in Georgia?
So the last part of that question is it's up to that vendor. I don't think there'll be a lot of problems with online sales. The problem is that they have criminalized the retailers, and that puts a chilling effect on the retailers who will be willing to sell Kratom product, and therefore restricts access by people in Georgia if that eventuality occurs, as I suspect it will. And this is the important thing. The retailer understands that they're not going to get convicted of it, but when a trial attorney just to get them onto the docket sues them, they have to hire a lawyer to defend themselves. And to some point, it's not worth it. And they certainly can't get insurance if they're going to continually be sued by a group of trial attorneys. So this is a complex problem. That's why we don't like the bill, because it demonizes retailers, it over criminalizes them, and we think that's inappropriate. The actual standards of the bill with respect to the Kratom products, we don't have a big problem with. We don't think it's well grounded in the science, but it's not bad. And we can live with it until we get more scientific data to address what the specific product formulation limitations should be. But right now, that bill, the problem with the Georgia bill is that it will have a chilling effect on retail sales in the state of Georgia. And we don't think that's a good thing for the consumer population in that state.
Right. And is it too soon to know what the extract criteria is for the human study? I don't trust them, as I don't know the method of extraction nor the strength. I do know that some are way too strong.
So the decision about the study protocol will be made internally at the FDA. And if the scientists cede control of that decision to the policymakers who have no business in that discussion, then it will be an unfortunate event. But there is a movement to have a human abuse potential study done privately, and that will be, I think, a very important study to keep the FDA honest. I'm hopeful that the FDA scientists will do as they did with the dose finding study, at least stay true to the science, and we're hopeful that that'll happen. But we're going to watch them closely. There's no guarantees, but if they overreach, we'll be able to see it. And if they try to come out with results that are clearly the product of they're putting their thumb on the scale in order to tilt to an anti-Kratom position, we can identify it, and we'll have sufficient evidence, and it'll be difficult for them to implement a public policy if they've egregiously designed that study protocol.
Great. And in terms of legislative malpractice, what mechanism does the public have to undo such or make them do their job properly?
So this is a great question, and I'm going to violate my principle of not. This is going to be a John Schinzelter moment for me. The way that you control that is you throw the bastards out, and that's what's got to happen with Representative Townsend. Now the problem is Kratom's not that big of an issue in the overall scheme of things, but what he did was wrong. He sold his office to a group of trial attorneys, and the evidence of that is look at his campaign contribution. The largest campaign donor to his campaign, other than himself, because he gave his campaign a lot of money, the largest individual donor to Representative Townsend's campaign was Matt Wetherington, $3,300, $3,200. One of the second largest was another attorney that's involved in the cases. And he says to me with a straight face, "Oh, the trial attorneys had nothing to do with this." That's complete nonsense. And the evidence, look at what happened in the hearing when he couldn't answer a question. Who leapt up to the podium? And I've already said it, Matt Wetherington. So, and by the way, Matt Wetherington's a very sharp attorney. He's a very successful attorney. He's a skilled attorney, and he knows how to move public opinion. And he's using every resource that he can. I mean, look at what he did. He's very skilled at artificial intelligence. He tried to create misinformation within the Kratom community and to gin up the people in the Kratom Danger Awareness Program by taking a picture of my wife and I with Senator Joe Manchin. He put his head, this is Matt Wetherington's head, 2 decades ago, a very young guy, and it made it look like that he and I were friends and have been friends for years. That is false, not true. He knows it's not true. And his weak excuse and it's up on Twitter, you should go read it. He said, "Oh, well, I asked permission and I was told you would be okay with it." Well, who did he ask? He didn't ask me. And who would be in a position to know whether I would be okay with whether he could manipulate through artificial intelligence and falsely put his head on Joe Manchin's body? Now, my wife had the biggest objection because the AI program put a lousy color on the blouse. She said, "I've never wear a blouse like that." So my wife was really mad at him, but he was trying to mislead people. There's no other purpose for it. He misled people into believing that he and I somehow had a long-standing relationship, which would undermine my credibility in the Kratom community by making it look like we were in cahoots together. It is false. And he did it deliberately, manipulated the picture. That's who we're dealing with. Smart advocate, no question about it, but I'm not sure that that's the way you get things done when you falsify a picture. If that's the tactic he's willing to do, is it any surprise that when you read the complaints, that they don't seem to be quite accurate. Is it any surprise that the claims made in those complaints with respect to the FDA and their position on Kratom? Has he amended his complaint to say, well, actually, the FDA's changed their position and here's the scientific data on it? He hasn't done that because, again, he's a skilled advocate and for his clients, and we should take everything for a grain of salt that he's pushing. Now, he could say the same thing about me. He could say, well, Mac Haddow's just out pushing for the Kratom consumers. Yeah, I am. But I've at least got science and evidence to back it up, not from me. And this is a favorite thing he likes to say. And Representative Townsend said it too. And what Representative Townsend said was he knew was a lie. He said, oh, these are studies funded. The Johns Hopkins study was funded by the American Kratom Association. He said that on the record at hearing. Now, the only reason he thought that, there's only one, the trial attorneys told him that. It's a lie. And when I confronted him about it, he goes, oh, well, I was told that that was the case. It was not true. Johns Hopkins funded their own study, and he's talking about the one where they looked at the almost 3,000 Kratom consumers that used Kratom to wean off of opioids, 87% of whom said that it helped them with withdrawal symptoms, and 35% were opioid-free with using Kratom within a year. That was a positive study, and he wants to demonize and undermine the credibility of every study saying, oh, that was funded by the American Kratom Association. We have funded one study. There are hundreds of studies that have been done since 2016 or 18 rather, when Brett Chawla called the FDA's evidence embarrassing poor evidence and data. There have been hundreds of peer-reviewed published articles, and none of them were funded by the AK except for one, a rat study, and that was funded by another organization of which we helped to actually orchestrate the study. And it was the rat study using the FDA's protocol called the oxycodone protocol, which showed that at hundreds of times the amount that a human could consume, that there were no deaths in the product. We were simply trying to identify a safety profile, but they like to harp on that and say, oh, the AKA is funding all these studies. We are not. We focus on advocacy. We focus on moving the needle. And the AKA itself has never funded a research study. And the comments that were made by Representative Townsend, and to the extent they're repeated by the trial attorneys, are false, misleading, and inaccurate. Another word for a lie.
Thank you, Mac. And can you touch on Kratom in Arkansas?
So we just had a discussion today with our lobbyist in Arkansas. There will be a hearing, what they call an interim study hearing before the joint House and Senate Health Committee sometime in this summer. And they will give us the opportunity to educate the legislators who unanimously passed the approval for evaluating Kratom to repeal the existing ban and replace it with the KCPA. So I think we're doing great there. We'll circulate the word on when that hearing is going to be held for those that want to participate. There's important information that the legislature needs to hear, not only about the scientific profile and the safety profile of Kratom, but also what the impact of criminalization of Kratom consumers is in the state of Arkansas. They need to hear that story. And of course, I'm talking about Marshall Price's story. They need to see what the impacts of this horrible policy is that was instigated by one doctor that got through the ban in Arkansas. It's the most ridiculous travesty from a public policy perspective that I've seen, and hopefully we're going to be able to overturn that when we get into that hearing.
Great. And can you explain the difference between heavily MIT extracted products versus 7-OH extracted products? Are the 7-OH products confirmed to be less safe, or is there just a lack of science at the moment?
Well, it's a fair question, but here's the difference. A extract product with a high metrogenine content is an extraction of the plant material itself using a approved solvent for the extraction, which limits the power of that extraction. 7-OH is taking all of the metrogenine extract material. It's from an extract. It takes 7-OH and concentrates it and synthesizes it. It's a synthetic metabolite at that point, highly concentrated. And the difference is that it isn't less than 2% of the overall alkaloid fraction of the plant. It is multiples higher at levels that all of the scientists who have studied Kratom for years, some for decades, all have a consensus that it is a threat to the safety and threatens the entire Kratom community because people will call it Kratom. I think I have one. Well, here it is. This is one of these products. And if you can read it, it says advanced Kratom alkaloids. 7-OH is not an alkaloid, it's a metabolite. It's not advanced, it is synthesized. And it says that in these 3 tablets, the serving size is half a tablet. And the total amount of it's 14 milligrams per tablet. That is a highly synthesized, concentrated level 7-OH for which there is no known safety data, none. And the difference between an extract product, and we just did a survey of companies that have been on the market with extract products, concentrated extract products that are properly extracted using FDA-approved solvents, and for at least 2 years on the marketplace, and no adverse events. That's the difference. There is absolutely no market experience for this product. They just put it on the market. Now there are multiples of this product. We're hoping that the manufacturers will see the light and say, we're going to wait and see what a synthesized version of 7-OH, what its safety profile actually is. And that's going to take some study to get done.
In a toxicology exam with the 7-OH and mitragynine, can they be distinguished from each other, or will the difference between them, the two, be able to be noted?
Any legitimate test of a certificate of analysis generated by a laboratory that is credible, independent laboratory, can easily tell the difference. There's not even a question about it. And the differences are stark. They're readily identifiable, and it's easy to know which product is a synthesized version versus a natural product.
And hello, we have a natural organic wellness store, Natural Life, Alpharetta, Georgia. Kratom is our best seller. What is the chance Kratom will be outlawed in Georgia? FYI, we sell to no one under the age of 21.
Well, I think the one positive outcome of the debate that's gone on in Georgia is that there is, in my opinion, a minuscule chance of any ban, because the recognition by legislators is that it just needs to be regulated. And what we need to get to is the proper regulatory framework. And that's it. I don't think there's any risk at this juncture of a ban. The only way that would happen is if somehow 7-OH products got out there, there was some safety issues that were identified, maybe even some deaths, and that led to a decision that all Kratom had to be banned. And that's a threat. And so we want to guard against that, which is why we're being so aggressive on 7-OH products.
Great, thank you. And a little different to what you answered before. What is being done about the 7-OH products currently on the market in states that have KCPA laws in place? Are those products technically illegal due to the high concentration of 7-OH?
Yeah, first, those products are illegal, simply because of the content of them. Those KCPA states say either that you cannot have a 7-OH presence of greater than 2% of the overall fraction of the plant, or in some states 1%. And these products way over, and they're illegal in those states, which is why the manufacturers of these products are so upset with the American Kratom Association and why they're attacking us. So we're going to have to stand tall on this. We'll take the spears and arrows that they sling, but we're going to fight hard against this because these products have no known safety profile for which they could document that they should be marketed to consumers at this point. If they have the data, show it. They did convene a meeting that we helped organize with a couple of leading scientists, and they claimed, the manufacturer of these products claimed that they had safety data. They had none. They had some anecdotal, interesting information, but there's been no data that's been generated by actual studies. And the only science that's out there are the science that's been done, the research that's been done by known Kratom scientists who have very serious questions about whether this product is safe at all. So we need to wait and see. But until then, until they can say a synthesized product is safe, then we should have that data before we say it's good to go in the market. My opinion.
That's great. From Melody, maybe explain anchoring bias. I mean, it's killing us. We have to get to our representatives, local and state first.
So this is an interesting term because I've heard different definitions of it. But what it essentially says is that when someone decides, because an influencer comes in and tells them that something is bad, in this case, the FDA says it, or the Mayo Clinic says it, or a local addiction recovery center says it, and you go on Google and you see it, and so you create this bias that's anchored by misinformation. And this commenter is exactly right. We need to fight back against that to deprogram some of these people, and we need to educate them on what the science says. And nothing is better to fight this than actually looking at this emerging science and the FDA's own data. And as much as Matt Wetherington tried to come out and say, oh, the FDA didn't say anything like that, we have a slide deck that is branded with the FDA logo, which was presented by the FDA scientist from the Controlled Substances staff, Chad Reising, at the third International Conference on Kratom on February 16th. It's his FDA slides, and those are available on our website today. That's the FDA. Now, Matt Wetherington didn't know that we had that slide deck, and so he, fired before he thought or knew, and he was claiming, oh, well, they don't have any data like that. That's not what the FDA says. Now, the trial attorneys have retreated to saying, oh, well, it's not definitive. It wasn't intended to be definitive. It was only supposed to clear the way for an ethical study in humans of a human abuse potential study, but it is sufficient data by the FDA's own description that kratom is well tolerated across all dose levels. And more importantly, the FDA's premise that when you take 2 grams of kratom, that you're going to suffer a seizure, you're going to go into some sort of organ failure, was wrong. And they now know it's wrong. And so, you can't say out of both sides of your mouth, kratom's dangerous, like they do on the FDA and Kratom website, and then say that it's well tolerated across all dose levels, and say all we're looking for is to make sure it's properly manufactured, properly labeled, and sold to adults. I mean, if that's what they're after, then they should embrace the KCPA and let's move down the road.
Can we sue the FDA at some point for all the lies, stress, and money they've caused?
You can file your complaint under the Information Quality Act, and that will be a formal complaint that we're going to submit that will force the Department of Health and Human Services to evaluate the statements made by the FDA. The FDA has considerable leeway, hard to sue them. You can sue them, and we're looking at a couple causes of action that relate to the import alerts and some other issues. But I think the best strategy here is what we're doing with our FDA Truth website, to actually have citizens file complaints, and we're going to submit those to HHS for review, and we're going to give them to members of Congress so that they can prosecute that case as well.
That's great. And from Cami, are we working on reversing the Newport ban?
Well, we haven't taken any specific action yet because we're still working on gathering some information. We did get 1 vote, but remember that 1 vote came without a single question or a single comment. That issue was baked there, and so we're working on finding a pathway in order to re-educate those members and hopefully find a rescission of that. I think that the California bill, if it's properly framed, and if we can come to an agreement on it and it gets passed, will wipe out that regulation anyway.
Thank you, Mac. And our final question, there's a couple comments, but just our final question is, so in Georgia, you're saying it's more so of a problem for in-state vendors and shouldn't technically have an impact for online sales to consumers?
Well, no, the bill does apply to online consumers just as much as it does to the local people. They can still be sued. If they sell to someone under 21, they can be sued. If they don't properly label their product, or they manufacture a product that has the contents that are in violation of the law, they are equally at risk. So yes, the online vendors are just as much at risk, but it's the target that is painted on the backs of retailers, because the retailers really don't know what their products are. One of the questions that was asked during the hearing of a kratom vendor from Georgia by one of the state senators was, well, how do you, when you get your product, who stocks your shelves? And she said, I don't know. Now, this is, she's buying a kratom product, believing and the representations of the vendor, of the manufacturer, that what they're saying is a kratom product, that it is, that the labeling that's on it, is. The retailer doesn't have any independent way of knowing unless they were to crack the seal, send the product out for testing, which is enormously expensive. Why would they do that? And yet that's what the Georgia bill does. It criminalizes them if they're selling a product that is not compliant with the state law. Now, they're not going to get convicted of this, but they'll have to go to court. And that's what the Trojan horse argument by the trial attorneys was. They want to put a chilling effect on the sale of kratom products in the state of Georgia. More importantly, they wanted They wanted to be able to go to court and say, even the state of Georgia says that this, and then they quote the penalties, the criminal penalties that are associated with it, and they're going to try to attach that demonization in their lawsuits. That's the game here. Has nothing to do with good public policy. It has only to do with enriching trial attorneys and getting settlements that they're not entitled to under the existing law. They just want to expand their, at least from our perspective and in our opinion, they want to expand their list of defendants that they can pick their pockets. And that's really an unfortunate bastardization of the public policy we ought to be concerned about and working on as we go forward. I mean, you see the tactics that they are willing to go to. You had Matt Wetherington post on Twitter the point that one of the testimonials that we posted of Georgia consumers was a stock photograph, and then he went to lengths to point out that the Federal Trade Commission doesn't allow that kind of thing to be used, a stock photo to be used to promote a product. That's what it says. And he went to the Kratom danger awareness people and said, oh, you need to gin up complaints to the Federal Trade Commission and the FDA about the AKA using stock photographs to promote and sell a product. Well, here's the problem. First off, we don't promote or sell any product. We allow consumers to make an informed judgment about a list of products that have gone through a GMP program, but we don't advocate for consumers to buy any specific product. We don't sell it. And if you read the FTC guidelines, which I did, and I pointed out to Mr. Wetherington, they have nothing to do with what he's claiming. He falsely claimed that the use of a stock photo in one testimonial, and by the way, it was something that the particular individual didn't want their picture up. It was not a distortion in any way. Her story did not change. There was nothing fake about her story. Her story is real, that she struggled with alcoholism and the Kratom saved her. And it saved her from alcoholism and all of the negative effects of that. And that was her testimonial. And she stands true to that. But you hear Matt Wetherington say, oh, she flipped. She flipped. And then he used an AI, an artificial intelligence generated video to leave the viewer with the impression that that was really the individual who was changing her story about Kratom. That was untrue. These are the tactics that they'll use in order to mislead people and get them to look away from the truth being that Kratom should be properly regulated and consumers should have the freedom to use it as they see fit, as long as they know exactly what the product is, what the serving sizes are, and what the risks are associated with it. Nothing wrong with that. But that's what the trial attorneys don't want you to know or the public to know. They want to just keep firing away in lawsuits, and that's all this was designed to do. And I'll say it again, shame on Rick Townsend, a representative elected by people to stand up for the truth, and he did not do so. And shame on him. And I think that he should suffer that consequence as we go forward. I hope he will.
Thank you, Mac. And we have one final question now. As a vendor who ships products to Georgia, what can we do to ensure a smooth and problem-free environment for us and our retailers?
So great question. Make sure you're compliant with the labeling requirements and the product formulation requirements, which shouldn't be difficult. And then reassure your retailers that you are compliant with the law so that they will not be put at risk when they go into the retail, when a consumer comes into the retail establishment and buys your product, they know it's compliant with the law. That's the best protection. We can fight, Rick Townsend for his deceiving the legislature. We can fight the trial attorneys for their deceptively including provisions that did nothing but enrich themselves and add defendants to their list of lawsuits that they promote. What we want is for every Kratom consumer in the state of Georgia, when they purchase a product, whether online or in a retail establishment, to know that the product's compliant, properly labeled, manufactured properly, and not available to kids. That's it. And I think that method works. And all the misinformation and all the misinformation that flows from one source, which are the trial attorneys, was evidenced in the hearing when Rick Townsend embarrassed himself. And I'll give you another example, and it's one you can go look at. He started talking about the lack of enforcement. He said, you can't solve this by money. This is when he was on a tear about his van bill. He said, you can't solve this with money. He said, look at the state of Oregon. They put $1 million into it, and they have been ineffective in regulating Kratom products. I have no idea what he's talking about, because Oregon is regulating Kratom products according to the KCPA that was passed in Oregon. Where did he get that other than some made up fantasy, a fake reality that was created by the trial attorneys? And he listened to them to his detriment. And after he gets repeatedly exposed for making ridiculous statements because I shared that with him, he doesn't care, which tells me that's why money speaks more loudly in his ears than the truth does. And that's why I think he needs to be held accountable by his constituents.
That's great. And thank you, Mac. And thank you all for joining us this evening. Do you have any other closing comments, Mac?
Just my traditional thank you. And it's sincere. Thank you to all of you who contribute every day. There are influencers in our community that are leading in researching. They're leading in informing our constituents. I see new resources popping up every day. I mean, you've got the ladies that do the Kratom podcast, which is great, fabulous stuff. You've got Mike Overstreet with his program. These are important voices that need to be amplified as best we can. So go on and share them. Go on and promote them and get people to listen, because they're invaluable to really promote the truth about Kratom and good public policy that we all advocate for. So I'm very grateful to have that opportunity. When I had the opportunity to go to Rhode Island recently to testify before the House Corporations Committee on our bill, I got to meet again our great advocate there, Claudia Morandi, who is a champion for patients in pain. And she recognizes for some of them that Kratom can be an answer. And she's a great advocate for it. She has no interest in it other than helping people. And I think that that's the attribute that is part of the majority of our community. They have no self-interest. They're interested in helping others to achieve the same level of quality of life that they themselves have experienced because of this great plant that's helped them. And our fight is against those that try to interfere with the right of consumers to have access to safely formulated and manufactured, properly labeled products. That's the name of this game. And they need to get off their high horses and their own self-interest in some cases for our critics and recognize that there's a pathway here for proper regulations, which we all support. And not just with our faint, damning us with faint praise. We really believe it. And they need to come on board and help us to do that as we go forward. And I'll just give you this one last anecdote. In the state of Maryland, when we testified, the father who testified about his son who struggled with Kratom, but actually died because he went on to other substances, he told me that he didn't want to see Kratom banned. But if you listen to the trial attorney, they were saying that's exactly what he wanted. And it wasn't. They misrepresented the view of that individual who really had a more balanced view of this and recognized that there were struggles that people have, his son included, that led them to other substances that eventually that may have caused their death. We need to be the voice for responsible use, the voice for consumers to have the right to responsibly consume Kratom products, and we're not going to stop just because these people want to fight us and for their own self-interest. So thanks to everyone for standing up. I'm proud to be a part of a movement, and it truly is a movement today that we're making a real difference in public policy. So thank you.
Well, thank you, Mac, and thank you all, and have a wonderful evening, and we'll be in touch in the next few weeks.
Thanks, everyone.